Hello everyone. Excuse my sore throat today if I sound a little bit hoarse. Good morning and welcome to this morning's Knowledge Bank, which is hosted by the lovely Cassandra Zanelli, Solicitor and CEO of Property Management Legal Services. Cass is going to be taking you through everything to do with breaches of leases today. If you have any questions, please feel free to submit them via the Q&A button at the bottom of your screen, and Cass will try to get through as many as possible. Today's session is being recorded, so if anyone misses the session, I will be able to send it out to you later. Obviously, you won't hear me live right now. And if anyone would like to watch it again, I will also be able to send you the recording to watch back. So without further ado, I will now hand you over to Cassandra.
Thank you. Good morning, everybody. I hope that you are all staying safe and well. Thank you to Vicky and News on the Block for inviting me along to speak to you this morning in connection with breaches of lease. And with the number of people that have joined this morning, it seems that you are having some issues on your developments with regards to people breaching the terms of their lease. So hopefully what we're talking about this morning will be useful to you and give you some tactics and support in relation to what you need to do to address those people who are breaching the terms of your leases. There aren't any slides. Those of you who have seen me present before know that I am not a massive fan of PowerPoint, and that's probably understating it. So there are no slides. Depending on what we talk about today and the different cases that we talk about, I'll be able to share with you afterwards via News on the Block some briefing notes about those cases. I tend to think that they're a lot more useful to you guys than PowerPoints and slides and the like that lose their meaning relatively quickly after a presentation like this. So we'll have a chat this morning in the next hour or so about breaches of lease, about how you can and should be handling those breaches of lease. And as I say, if there are any cases that we discuss where the notes would be helpful to you to receive afterwards, then shout up and let me know, and I can send those to Vicky and she can circulate those to you. We're not together in the same room at the moment with the situation being like it is, but you do have the ability to interact with me, and you have a question box on Zoom. So if there are any questions that you want to ask or comments that you want to make as we go along, then by all means do shout up and ask those questions or make the comments that you want to make. Obviously, I can't talk about existing cases that you're dealing with, but I can give you some general pointers in relation to breaches. So shout up as we go and we'll pick up the questions as we go. Don't feel that you need to wait until the end to ask me anything. Bit of free legal advice, eh? Who knew? So today, for the next hour, we're going to be talking about dealing with breaches of leases, and we're going to be looking at lease covenants and understanding the differences that there are between qualified covenants and absolute covenants. And your leases will contain a mix of qualified and absolute covenants, and we'll look at that in a bit of detail. We'll look at some of the common breaches of lease that you guys face on a regular basis. So pets, subletting, unauthorised alterations, those kind of common breaches that you come up against with some frequency. We'll also look at evidence gathering. So what you guys need to do in order to gather evidence to be able to demonstrate that the leaseholder is in breach of the terms of their lease to either a tribunal, if you go down the line of making a tribunal application, or to a county court, if you go down the county court route. And we'll also, in the context of that, look at identifying the remedial action that your client wants to be undertaken. What remedy does your client want? I think a lot of the time we launch into a leaseholder being in breach of their lease and telling the leaseholder that they're in breach of the lease without necessarily giving a huge amount of thought to the remedial action that you want that leaseholder to undertake. So what is it that you want them to do? Because it's all well and good telling them that they're in breach, but what do you want them to do about it? And then we'll look at going legal and what the process is when you go legal, what the options are in terms of tribunal and county court, and ultimately what can happen to a leaseholder where they breach the terms of their lease. So in terms of an overview of the process, and this is a very broad brush overview of the process, and I accept that there is a scale of breaches, and some breaches sit at the bottom end of that scale and some are a heck of a lot more serious and sit at the top end of the scale and are probably dealt with rather differently if they sit towards the top end of that scale because of the nature and seriousness of them. So this overview that we're going to talk through is going to apply in the majority of your cases, but recognizing that in the most serious, that those are probably dealt with slightly differently, and the steps that you will take to deal with the breach will probably be done quicker than you would as a general rule. So somebody who is causing issues with fire safety, for example, you'll probably deal with much more expeditiously than somebody who simply has Vinny the dog in their flat and Vinny's not permitted to be there. I say Vinny the dog because there's a famous case from a couple of years ago dealing with Vinny the dog and his humans who wanted to keep Vinny in their flat and they weren't permitted to do so. And they were upset about the fact that they couldn't have Vinny in their flat. So an overview of the process will generally start with the alleged breach being reported, either by upset leaseholders because their next door neighbour is causing a nuisance, or however the breach is reported. The breach will be reported to a managing agent or to the landlord or to the management company. And so that report of the breach is made. You'll then be, as the next stage in the process, you'll then be looking at the lease, recognizing that each lease is different. So leases differ from block to block to block. But you'll be looking at the lease in light of the allegation that's been made and investigating that allegation to see whether, in light of the lease, there has been a breach of the terms of the lease on the part of that leaseholder. And you'll begin to gather evidence in relation to that allegation that's been made of breach. You're then working with, if you're a managing agent, working with your client, if you're a management company or landlord, you'll be making the decision in relation to the action that's taken against the leaseholder for breach of their lease. So what action are you going to take? And what's the remedy that you're seeking in relation to that leaseholder who's in breach of the terms of the lease? So you've understood that there's a breach, you've considered the lease and you think that those lease clauses have been breached. What are you going to do and what do you want to happen? That's the really important bit that I think sometimes is missed. What do you want to happen to regularise the situation for it to be put back how it was or should be? You will then either as management company or landlord or agent acting on behalf of management company or landlord, you'll then write to the lessee, tell them that they're in breach of the terms of the lease and point out the lease clauses that are being breached, point out the particulars of that breach, and also set out what remedial action you require. What is it that you want to be done to put right that breach? In a lot of cases, the lessee will listen to what you're saying, either as landlord, management company or agent, and they'll rectify and remedy the breach. If they don't, then the next stage in the overview is probably to go legal. And when you go legal, your solicitors will send a letter before action or LBA to the leaseholder who's in default, and that LBA will set out what the terms of the lease are, why those terms are being breached, what remedial actions required, and what further action is going to be taken in the event that the breach isn't remedied. If the breach isn't remedied on the back of that letter before action, then the next step in the process is probably to make an application to either the first tier tribunal property chamber if we're in England, leasehold valuation tribunal if we're in Wales, for a determination that a breach of conditional covenant has occurred, or it's an application to the county court for a declaration that there's been a breach of lease, maybe an injunction which prevents that breach, and perhaps a claim for costs and or damages together with interest as well in the circumstances. And that really depends on the nature of the breach that the lessee has committed. Ultimately, where a leaseholder breaches the terms of their lease, they stand liable to forfeit their lease. And forfeiture's a serious thing. It's a draconian thing And because of the nature and seriousness of forfeiture and how draconian it is, that's why we have various hurdles in a landlord's path that they have to negotiate, from the right to forfeit arising to the right to forfeit being exercisable to forfeiture actually taking place. There are steps that a landlord would need to follow. But ultimately, as I say, a leaseholder who breaches the terms of their lease stands liable to forfeit that lease. So that's a broad brush overview of the process, and we'll delve in a little bit more detail to the various elements of the overview of the process. But for your point of view, the questions that you need to be asking are, when you get a report that a leaseholder is in breach of the terms of their lease, what is the report? What are the covenants that are potentially being breached here? Are they being breached? How are they being breached? What's the remedial action that you're seeking or that your clients are seeking? And how are you going to go about the business of enforcing this and taking action if the leaseholder doesn't take that kind of remedial action that you've set out? So those are the key questions really that you guys will need to be asking yourselves and asking your clients in relation to any breach action that's taken. The starting point with all of this, and I say this and jump onto my soapbox at this point, are your leases. You need to make sure that you have read, understood, and implemented the terms of your leases. And I know that my clients probably get bored with me saying all the time, read, understand, implement. But that little mantra, if you can keep that mantra in your head, and when you're dealing with anything property management related, life tends to get a bit easier, because you need to make sure that you have read, that you have understood, and so importantly and crucially, that you have implemented the terms of your leases. So before you embark on taking any action against a leaseholder who you think might have breached the terms of the lease, you need to actually read the lease. So you need to read the lease and understand what your lease says. If it's an allegation that they're keeping pets and they shouldn't be keeping pets, what does your lease say about pets? If it's an allegation that they've made unauthorized alterations, what does your lease say in relation to alterations? What does your lease say in relation to failing to keep the property in repair? What does your lease say in relation to subletting and the dreaded Airbnb and other platforms and kind of shenanigans that go on in your blocks these days? So important that you understand what your lease says, because it goes without saying that before taking any breach action, you need to actually understand whether your lessee is actually in breach of the terms of their lease. And your leases contain covenants. Covenants are promises, and leases contain covenants on the part of all parties who are a party to that lease. And leaseholders will give covenants in relation to how they use the property, how they behave in and around the property and their flats. There's a whole raft of covenants that are contained within leases. And those covenants divide into a couple of camps. One of those camps is qualified covenants, and another one of those camps is absolute covenants. And your leases will contain a mixture of both qualified covenants and absolute covenants. Things that are a qualified covenant in one lease might be an absolute covenant in another lease. So things change from block to block to block. You can't rely on having read the pets clause in one of your leases to think that it's going to be the same pets clause in another of your leases for the block next door or the block down the road. And in terms of the difference between the two, a qualified covenant stops or prevents a leaseholder from doing something unless permission is given or granted. An absolute covenant or an absolute prohibition is what it says on the tin, in that it's an absolute prohibition or bar against something being done, certain action. I'll give you an example around pets. So an absolute covenant in relation to pets would read something like, and we know that they all read differently, but we read something like the leaseholder is absolutely prohibited from keeping pets in the flat, or no animals to be kept in the apartment. Full stop. Not a question of consent, it's an absolute bar against Vinny the dog and his mates living in that flat. A qualified covenant in relation to pets might read something like, the lessee is not permitted to keep animals within the flat without prior written permission of the management company or landlord. So that's the difference. Qualified is a consent issue. Absolute is an absolute bar against that certain act or thing from happening. You need to understand when you're dealing with a breach of lease, whether you're dealing with a qualified covenant or whether you're dealing with an absolute covenant, because the remedial action that you propose and that your clients propose is going to be different, probably depending on whether you're in qualified covenant territory or whether you're in absolute covenant territory. If you're in absolute covenant territory, you're more likely to be saying, you need to put this right, you need to stop doing what you're doing, or whatever it may be. If you're in qualified covenant territory, you may be saying, well, you shouldn't have Vinny the dog with you, but we might be minded to consider granting you permission if you follow the application process that we've set down. There is a difference in how you will react to whether a leaseholder is in breach of their qualified covenants or whether the leaseholder is in breach of an absolute covenant. And you may find with some of your breaches that the lessee is in breach of a number of covenants. Some will be absolute, some will be qualified. Important that you read and understand your leases and understand whether you're in qualified covenant territory or in absolute covenant territory. Remembering the cautionary tale, guys, of Duval and 11 to 13 Randolph Crescent, which was a Supreme Court case from, gosh, probably about a year and a half ago now, something along those lines. And that was all to do with unauthorized alterations. Happy to share the note with you afterwards if you think that would be useful. And in Duval, the leaseholder had sought permission to knock down, I think it was about 8 meters of load-bearing wall or something along those lines. And in her lease, the leaseholder had a covenant where she was not to cut, maim or injure walls. I always feel very sorry for walls at that point where it talks about cutting and maiming and injuring them. Walls have feelings too, apparently. But the leaseholder in her lease had this covenant, and it was an absolute covenant against cutting, maiming or injuring walls. Notwithstanding that absolute covenant, the landlord gave permission to the leaseholder to knock down that 8 meters or so of load-bearing wall. The other leaseholders, and particularly one of the other leaseholders in the block, was somewhat unhappy with that and with the fact that landlord had given permission for something that would otherwise be an absolute prohibition. And what the leaseholder did is that the leaseholder took action against the landlord, saying that the landlord was in breach of the covenants that the landlord owes to the rest of the lessees, because the landlord in leases tends to covenant that all leases will be granted in similar terms, and that where a leaseholder breaches the terms of the lease, the landlord will take action in relation to that. So one of the leaseholders who was particularly upset about the fact that the landlord had given permission to Duval to do something that would otherwise be a breach of an absolute prohibition, took action against the landlord, and the Supreme Court said that yes, the landlord was in breach of their lease by licensing something that was a breach of an absolute prohibition. So be very careful, people. This is why I stress it's so important you understand if you're in absolute or qualified territory, because if you start giving permission for a leaseholder to do something that would otherwise be an absolute prohibition, you may well find yourselves, if you're landlord or management company, facing action from your other lessees saying that you shouldn't have done that, and you may well find yourselves on the receiving end of a damages claim. Be careful where you're giving permission if you do give permission for something that would be an absolute covenant. In the words of the kids from Grange Hill, don't do it. Or be very careful if you do it, and seek suitable indemnities. So back to what I was saying before I went off on my soapbox rant. Understand your lease and understand whether you're in absolute or qualified covenant territory, and be very careful if you are in absolute covenant territory if you start thinking about giving permission, for example, for alterations where those alterations have, say, cut, maimed or injured a wall, and there's an absolute prohibition against cutting, maiming or injuring walls. You will then need to, once you understand whether you're in qualified or absolute territory, you'll then need to start to gather evidence about whether or not those covenants are actually being breached. Can you prove, or would you be able to satisfy a tribunal or a court that there has been a breach of lease on the part of the leaseholder? And your evidence gathering is going to depend largely on the nature of the breach that's alleged. So the evidence that you gather for one type of breach will probably be different to the evidence that you gather for a different type of breach. And for example, the evidence that you gather for unauthorized alterations is going to look very different to the evidence that you gather for nuisance behavior or pets in a flat. You need to tailor your evidence gathering to the nature of the breach that's been alleged. And I was thinking about this and thinking about what it is that you would perhaps need to start gathering at this early stage for some of the typical scenarios that you guys come up against. So for unauthorized alterations, for example, perhaps you've received reports of works being undertaken. You'll need to keep a careful note of those reports that are made, and whether it's via email, letter, whether you've had a telephone call from the next door neighbour complaining about all the banging that's been going on. Keep a very careful note and a careful record and a contemporaneous record of reports that are made to you and complaints that are made to you, because it may be that those complaints and those records that you're keeping form part of the evidence and the witness evidence that's presented to a court or tribunal in due course. What I always tell my team is that when they are writing any letters or emails or notes on a file, that they think about what they're putting in those notes and those letters on the basis that that's going to be presented to a court in 6 months' time. Are you happy with how your emails and your letters and your notes read? And are you comfortable with a tribunal judge or a district judge, maybe even a high court judge, looking at those in 6 months' time? Do they reflect you? Do they reflect the conversation that's taken place? Make sure that your notes are comprehensive, accurate, and contemporaneous, just in case we ever need to use them and rely on them in court, and maybe call you to give evidence about those notes as well. Be comfortable with what you're putting in emails and your notes. For unauthorized alterations, you might get noise complaints, as I say, from next door or from some of the other lessees or residents in the block. There might be evidence of the works being undertaken. Maybe you've got contractors knocking around in your building, leaving dirty footprints up the stairs. Maybe there's debris knocking around, where they've ripped out the kitchen and they're installing a new kitchen. There will be signs, there will be evidence of works taking place. So gather reports of that. If you've seen a bathroom dumped in the corridor or dumped outside rather in the corridor, then take photos of that. Gather the evidence that you would rely on to show the court that there has been unauthorized alterations that have taken place in that flat. Most of your leases as well will contain an access covenant, which entitles the management company or landlord to access the flat. Access covenants are worded differently from flat to flat to flat, but it may be some have different triggers. So some are more open-ended, some are narrower in terms of the circumstances in which you can access or obtain access to the flat. Have a look at your leases, see whether there is an access covenant, see whether the circumstances have arisen so that the access covenant is triggered. And if so, seek access to the flat, carry out that inspection, making sure, of course, that you keep a detailed and contemporaneous note of what you saw and what you witnessed during that inspection, having utilised your access covenant. That will start to give you the basis of being able to take action against the leaseholder for breach of their lease for can't speak, it's not good, is it? For an unauthorised alterations matter. So far as pets are concerned, again, you're probably going to get told about that because of noise nuisance. Maybe there's a dog barking in the flat and the next door neighbour or neighbours around can hear that. Perhaps Vinny the dog has been seen wandering the corridors with his human or wandering the grounds with his human. You'll get people telling you that there are dogs in and around and wandering around. Maybe you've got CCTV on site and you can see Vinny and his human wandering the corridors on the CCTV and outside in the car park, the grounds, whatever it might be. Maybe you've even got a picture of Vinny at the window. Who knows? But you're likely to have some reports and some sightings, and you'll therefore be able to form a comprehensive record of the reports and sightings that are reported to you or that you have witnessed yourself. And again, maybe you wanted to utilise the access covenant to see whether Vinny's living in the flat. That's the kind of evidence that you might be gathering so far as pets are concerned. If you have a concierge on your developments, then or caretaker, they're going to be the eyes and ears, aren't they, of your building? So they will see lots of people coming and going, contractors coming, going, Vinny the dog coming and going because he's been let out for his daily walk or whatever it might be. Your concierge or your caretaker, your building manager, will be able to provide that kind of evidence, and it may well be in due course that witness statements are taken from that person as well as the reports having been made to you guys. So far as short-term letting is concerned, because this is another one that comes up quite a bit, isn't it? Again, the Airbnb stuff tends to be triggered, doesn't it, by you getting reports of nuisance behaviour. There were lots going off last summer, wasn't there, with party flats. When everybody came out of the first lockdown, it seemed that lots of flats were being rented on a party basis. Haven't had quite so many reports this summer of the same kind of shenanigans, but maybe you're experiencing difficulties with Airbnb and similar platforms in your blocks. As I say, it tends to, in my experience, come across your desk or come to your attention when there are reports of nuisance behaviour, when there are reports of a large number of visitors, when you carry out your site inspections and you see those key safe boxes on the railings or outside of the doors. It's always a bit of a giveaway, isn't it, when there's one of those there. You may then go on to Airbnb websites and you may find the property listed on the Airbnb website. It always amazes me that you have on the Airbnb website, you have whoever it's the host, isn't it? I don't book Airbnb on principle because I get so many breaches of lease because of Airbnb. But you have the host, so you can see the picture of the lessee and their name, and you have their 50 reviews over the last 3 months where they have let it out to all and sundry. So it's not tricky to prove an Airbnb type breach when it's all there in glorious Technicolor on the internet. Do make sure though, before you send your first letter to the leaseholder saying, by the way, mister, that you have kept copies and screenshots and printouts of the website. You'd be amazed, and I'm sure that you experience this as well, as soon as you write to somebody to say, by the way, that the listing comes down pretty quickly. Keep copies so that you're able to show that the listing was indeed live on Airbnb and similar websites. None of my clients have done this yet, But ultimately, I mean, the best piece of evidence gathering that you could probably have for Airbnb would be to book the thing. So book it, pack it and turn up. And you will then be able to show, here's a picture of me putting the key in the lock. Here's a picture of me in the lounge. Here's a picture of me on the balcony, in the bathroom, in the bedroom, whatever it might be. And you've got your booking form. You've got your witness evidence showing that you turned up on the 30th of September and booked this place. And it was flat 13 and the whole gamut of photos and everything else to go with it. As I say, none of my clients have done that yet, but it's there as an option. And I think it's very difficult to say that you're or deny that you would be letting on Airbnb when you would be faced with that kind of strength of evidence against you. So those are some of the typical breaches that you will deal with and some of the evidence gathering that you might be doing. Important though, guys, that you are gathering that evidence. The burden is going to be on us as the party bringing either the application in the tribunal or the proceedings in the county court. The burden sits with us to prove that the leaseholder is in breach of the terms of the lease. It's no good just saying they've got a dog, prove that they've got a dog, or that they've made unauthorised alterations. You need to be able to prove that. You need to be able to prove that they're subletting, short-term basis, or whatever it might be. It's that evidence that's important. So you've investigated, having had a report made to you. You've read the lease in light of the investigations you've undertaken, and you've then been able to satisfy yourself that the leaseholder is in breach of one or more covenants in their lease. You need to think, and if you're managing agents, liaise with your clients at this point, in relation to remedy. What remedy do you want? So well and good saying Mrs. Miggins is in breach of her lease because Vinny the dog is in her flat. What do you want to happen? Is it a qualified covenant? You want Mrs. Miggins to enter into some form of consent or license? Or is it an absolute covenant and you want Mrs. Miggins to move out, Vinny? What is it that you want to happen? Decide that, because you're going to need to set that out in the next stage, which is your contact with the leaseholder. You will write probably to the leaseholder and you will point out the error of the leaseholder's ways. Your letter to the leaseholder will probably follow a similar kind of pattern to what my LBA would, in that you're going to set out what the terms of the lease are. So your lease says this in relation to keeping pets, or your lease says this in relation to alterations. You're then going to set out what the particulars of breach are. Why is it that you say the terms of the lease have been breached? What are the particulars of breach? You're in breach of the terms of your lease because you've got a dog residing with you in the flat. Dogs are not permitted. It is an absolute prohibition against dogs. We have a number of complaints received from residents. We have CCTV showing you and a dog in and around the building. You then will probably set out the, sorry, I've just seen that a couple of questions have come up. Fabulous. Just move there. Sorry, guys. Thank you for your questions. I'll look at those in a minute. You will then set out in your letter what the remedial action is. You've got Vinny the dog. There's an absolute prohibition against dogs in your lease. You will need to find alternative accommodation for Vinny the dog. Vinny the dog cannot live with you in your flat. It is absolutely prohibited. So set out what you want the leaseholder to do. And set out as well a time frame that you want them to do that in. It may be that you want a range of remedial action and you attach different time frames to both. If it's an Airbnb, we want you to take the listing down immediately. We want you to cancel all bookings. We want you to take no further bookings. And we want an undertaking within 14 days that you acknowledge the terms of your lease and that you undertake to comply with them, to adhere to them going forwards. You also will probably set out in your letter, and I would certainly do in my letter before action, what's going to happen next. If you carry out the remedial action we've set out above, then we're all mates again. If you don't carry out the remedial action we've set out above, then this is what's going to happen. We're going to instruct solicitors. Those solicitors are going to be instructed to take action against you. Let's not litigate things unnecessarily. But you need to be specific, I think, in relation to the next steps that are going to be taken by you in the event that the breach isn't remedied. I don't know about your experience, but in mine, I think quite a few of the, or quite a decent percentage of the breaches that will come across your desk are remedied at that point. Sometimes leaseholders hadn't understood or didn't understand that there's a process that needs to be followed, for example, for making alterations, whatever it might be. That initial letter from either from you directly or from your managing agent acting in your behalf sometimes works, and that it makes it unnecessary to go legal because the breach and the remedial action is undertaken. If it doesn't, then it is going to mean going legal. And that means instructing solicitors, and solicitors will then send a formal letter before action to the lessee. I hear from clients quite a lot that they send a letter and it's ignored, and they instruct solicitors to send a letter, which is a similar kind of letter, I have to say, in fairness to my clients. And just because it comes on a solicitor's letterhead, but it's taken slightly more seriously by the leaseholders. So a formal letter before action from solicitors, setting out what I've said in terms of terms of lease, remedial action, next steps, and giving them a period of time to remedy the breach. More than half, I would say, of the breach of leases that I'm instructed on, actually a lot more than half, resolve at the letter before action stage. It is rare to have to then go on to take enforcement action against a leaseholder who is in breach of the terms of the lease. And even rarer for that enforcement action to actually end up at a hearing or determination by either the court or by the tribunal. So this doesn't happen often, but it's the thing that you will do in the event that the leaseholder hasn't remedied the breach in accordance with how you want it to be remedying. So you have an option to apply to the first tier tribunal property chamber if you're in England, or leasehold valuation tribunal if you're in Wales. And that's an application that can be made under section 168, subsection 4 of the Common Hold and Leasehold Reform Act 2002. It's an application for a determination that a breach of condition or covenant in lease has occurred. Terrible grammar, but that's the name of the form. And the application is made by a landlord, and I'll come back to that in a moment, against the leaseholder who is in breach of the terms of their lease. The tribunal hold jurisdiction to determine yes or no whether a breach of lease has occurred. The tribunal will look at your application, look at the evidence that you present, and then determine whether or not the leaseholder is in breach of the term or terms of their lease. They will give you a determination as to whether the covenant or condition in lease has been breached. There's an application fee of £100. If the matter ends up at a hearing, then there's a hearing fee of £200 that's payable as well. Different application fees in Wales. These are the application fees in England to the FTT. Now, I said and was specific in the language that I used, in that an application to the FTT under section 168 is within the gift of the landlord. And that is the landlord. It's not the management company under a tripartite lease, unless the Manco is also landlord. it's the landlord. It's only the landlord who can make an application to the tribunal under section 168. And the landlord for these purposes is the person that's immediately expectant to the reversionary interest in the property. So if you are a management company under a tripartite lease, you cannot go to the FTT under section 168 for a determination. If you are the management company under a tripartite lease, or if you are landlord, you have the option to go to the county court. And you can make an application to the county court for, firstly, a declaration that your leaseholder is in breach of the terms of their lease, so that the tribunal have determinative power, the county court have declaratory power. You'll note the difference of language there. You can apply to the county court for a declaration that the leaseholder is in breach of the terms of their lease. You could also, depending on the circumstances, depending on the nature and seriousness of the breach, you could also ask the county court to grant an injunction. And injunctions are either prohibitory or mandatory. So they either require certain action to be taken or require certain action to be stopped, depending on whether they're prohibitory or mandatory. So you could ask the county court to grant an injunction that would stop the leaseholder from perhaps subletting on an Airbnb type basis, or if the leaseholder hasn't kept their flat in repair, that would require the leaseholder to put their flat back into a state of repair, depending on the nature of the breach. Injunctions are serious and they are an interference with somebody's rights. So they are not handed out by the court on a, forgive my technical legal phrase, willy-nilly basis. You have to be able to show to the court and demonstrate that they could and should exercise their discretion to grant an injunction. So evidence is really, really important for those purposes. As well as asking the county court to give a declaration and/or injunction, you can also ask the county court to make an award of damages together with costs and interest in relation to those matters. So the county court's powers are wider than what the tribunal's powers are, but there are advantages and disadvantages to both venues. Obviously, as I say, the determining factor often is locus. If you are management company, tribunal's out. If you are landlord, you can choose whether you go to tribunal or whether you go to county court. So far as advantages and disadvantages are concerned, one of the main things that people talk about is costs. The tribunal is often thought of as a no cost or low cost jurisdiction. And that's right, the tribunal's powers to award costs are really quite limited, not like a county court. The tribunal's power to award costs is either on a wasted cost basis, so where a legal representative or other representative has been negligent in how they've essentially conducted themselves, or what's more common is unreasonable conduct or unreasonable behaviour. It's Rule 13, where a party has behaved unreasonably in how they have brought, defended or conducted proceedings. But Rule 13 cost orders are rare. They don't happen often. It's a very high threshold that a party has to meet to be able to persuade the tribunal to invoke their discretion under Rule 13 and to make a Rule 13 cost order. You can't embark on tribunal proceedings in the hope and expectation that you'll get a Rule 13 cost order, because you probably won't. They're rare. I can count on both hands, and I don't need more than both hands to count the number of Rule 13 cost orders I've had, and I deal with tribunals a lot. The benefit, if you're a landlord, of going to the tribunal is that you are protected probably protected against an adverse cost order, so a Rule 13 cost order, because Rule 13 cost orders are rare. So long as a landlord you don't behave unreasonably in how you've brought or conducted proceedings, you probably won't find yourselves on the receiving end of a Rule 13 cost order. There is normally a contractual right or contractual ability on the part of a landlord to recover costs against a leaseholder who is in breach of the terms of their lease. So you have a contractual, or probably, depending on the terms of your lease, have a contractual ability to recover costs in the tribunal on a contractual basis. So you don't need an order from the tribunal. You've got the lease, which is your contract that you rely on to recover costs. That's recovery on an individual basis from the leaseholder. Your lease may well also allow you to recover costs or recover legal fees via the service charge mechanism, so via the service charge pot. Again, it's dependent on the terms of your lease, but most leases do allow for parties to recover their legal fees via the service charge mechanism. It's one of the heads of expenditure that service charges can be used for. That's why I favour sometimes the first tier tribunal for dealing with these kind of matters. If I'm acting for a landlord, I know that my landlord probably has the protection and won't end up with a Rule 13 cost order against them, but equally that the landlord is able to recover their costs either directly from the leaseholder because of the contractual right to recover where the leaseholder is in breach, or via the service charge mechanism, subject to there being a suitable worded clause in the lease. County court is slightly different in that if you go to the county court and seek a declaration and or injunction, then costs are what's called at large for proceedings of that kind of nature. The general rule with county court for these kind of things is that the losing party pays the costs of the winning party. If you go to the county court and you don't have sufficient evidence and you're not able to persuade the county court judge to exercise their discretion and grant an injunction in your favour, so if the leaseholder defeats your application, then you may well find yourself on the receiving end of an adverse cost order where you are ordered to pick up the leaseholder's legal fees. Ditto, if you go to the county court and win and get your declaration and get your injunction, then the county court may well make an adverse cost order in your favour. But costs are at large when you're dealing with county court matters. So important, therefore, that you have that evidence to be able to satisfy the court and to prove your claim. And it goes back to what we were talking about, doesn't it, with the evidence gathering side of things, that you need to make sure that you're gathering as much evidence as possible and that you're able to then demonstrate your claim to the county court or first tier tribunal. I can see that there's some questions and I'm not ignoring your questions. I'll come to those in a moment. Ultimately, if a leaseholder doesn't adhere to the determination of the FTT, then you will take enforcement action in relation to that, and the enforcement action is taken in the county court. Where a leaseholder is proven to be in breach of the terms of the lease, then they stand liable to forfeit that lease. So it is a serious matter. I know that it sounds simple and straightforward, doesn't it, that a leaseholder is in breach because they've got a dog, but ultimately a leaseholder could stand liable to forfeit their lease because of that. So these are serious matters and do need to be taken seriously. So an overview then, guys, just to wind it back to what we were talking about from an overview from your point of view, is that you're going to have the breach reported to you. You're going to consider your lease and investigate that allegation of breach that's been made to you and gather your evidence to support that. You're going to make a decision, either because your management company or landlord or agent acting on behalf of, in relation to what happens, what action you want to take and what remedy you're looking for here. You're going to correspond with your lessee and hope that that resolves it. It may well do. If it doesn't, you're going to go legal. Solicitors will send a letter before action. Hopefully, because most times that resolves it. If it doesn't, then depending on who you are, may well dictate whether you go to county court or tribunal. And if you're landlord and have the luxury of being able to choose, then you will no doubt take advice in relation to which is the most appropriate venue for you to go to, whether it's an application to the FTT or whether it's an application to the county court for declaratory and or injunctive relief together with costs, interest and damages. Hopefully that gives you a bit of structure in relation to how to deal with common breaches of lease that are coming across your desk, and a bit of structure in relation to how to deal with breaches of lease generally. I like a process, I like a procedure, I like some structure, and having that will hopefully help when you're dealing with these kind of things. So let's have a look at some of your questions that have come in. If you do have questions, then please by all means put them through and I can take a look at those. Sorry, I'm trying to multitask now and failing miserably, so forgive me that I'm not ever so good at multitasking this morning. Denica says, thank you for today, it's been really informative. You're very welcome. Glad that it's been useful to you. If a leaseholder who also forms part of the freehold company makes an alteration without prior consent, can they grant themselves a license at a later date, or would this consent need to be given by the directors of the freehold company? It's a director decision as to whether or not consent is given. So you would, if you're the directors of the freehold company, you'd call a board meeting. You may well ask the director who has carried out the alterations or proposes to carry them out to recuse themselves because of conflict or likelihood of conflict. And then as a board, you will decide whether or not to give permission for those alterations. And of course, you'll keep a note of your board meeting and a note of the resolution that you pass at that board meeting. And you will remember that minutes of your board meetings need to be kept for 10 years and that it's a criminal offence if you're not. Natasha, some responses are let the owners go legal, which doesn't happen as nobody wants to pay for it. What do you do then? That's I can sit here, Natasha, and tell you what your options are, but some of them do involve a cost and do involve a legal cost. So you have remedies where a leaseholder is in breach of their lease. You have the ability to take action against them either in the tribunal or in the county court, but I accept that there is a cost associated with that. And in order to pursue those, then that cost is going to need to be met. Abby, morning, Abby. Abby says, we've served a breach of lease notice on a leaseholder in relation to nuisance being caused. The leaseholder has reverted and stated that the behaviour is due to some disabilities. And the leaseholder suggested that the tenant is being provoked, wow, and by the director's partner. Abby, that's probably one that's going to take longer than the 5 minutes that we have to discuss. If you want to give me a shout and we can pick that one up offline, then I'm happy to talk that one through with you, because that brings in all sorts of issues in relation to that one, some of which we need to be quite sensitive with how we deal with them. So give me a shout. Anonymous says, consent given for an absolute covenant, is action possible against the freeholder retrospectively? Yes, because that's what happened in Duval, that the freeholder gave consent, so they licensed the knocking down of this 8 meters or whatever it was of supporting wall, and the leaseholder then took action. One of the affected leaseholders took action against the freeholder in relation to that, because the leaseholder said the freeholder had breached the terms of the lease that they had between that particular leaseholder and the freeholder. So yes, if it would help anonymous attendee, then I'm happy to circulate the note that I've written on the Duval case. So I'll get that across to News on the Block. Let's have a look. Please do keep questions coming in. There's a couple more. Oh, we've got a couple of minutes left at the end. Natasha says, if a dog is prohibited and the landlord decides that the dog can stay in situ as it's old and not a nuisance, and then later changes their mind as owners insist on its removal, will this affect any pursuance to breach of the lease? If you've given permission, then you have given permission for the dog to be there. This is why I think Duval is a bit of a problem for management companies, landlords, and indeed managing agents, in that you are often given permission for something to be done that's a breach of an absolute prohibition. Pets, wooden flooring, subletting. These are typical examples. By doing that, you are leaving yourselves open to actions being taken against you for damages, where you are giving permission for something that would otherwise be an absolute prohibition. You're licensing something that's an absolute prohibition, and your other leaseholders in your block, if they suffer loss as a result of that, are potentially going to come after you for the losses that they suffer. If I didn't like dogs, I like dogs, but say I didn't like dogs and I bought a flat in a block and the lease for those flats in that block specifically excluded the ability to keep dogs in the flats. It was an absolute prohibition against dogs. And I bought the lease because it had that absolute prohibition, because I dislike dogs intensely. If you as the management company or landlord then permit people to keep dogs in their flats, I am going to take action against you and take a claim against you for damages. I specifically bought a flat because it didn't allow dogs in that block. You have then gone and let a load of dogs in. I'm going to take damages, a breach of lease and damages claim against you for that. Be careful when you're committing things that would otherwise be a breach of absolute prohibition. We've got 1 more minute left because Vicky's going to jump in at any point now. Anonymous, if the lease allows Manco to create extra rules, do these still stand whether there's a new director and the rest have retired? Yes, unless I assume that you're talking about estate regulations. You need to have a look at your lease and see if your lease permits you to make estate regulations. And you need to make sure, of course, that your estate regulations don't contradict or seek to vary anything within your lease that they're supplementary to rather than a variation of. But yes, until such time as you amend those estate regulations, they stand. Vicky, I'm conscious that we're now, by my clock, 11 o'clock, dead on. Who knew?
I can send you a list of any of the questions that have not been answered this afternoon. So then if you want to get back to people directly, then Cass can do so. Thanks, Cass. That's been really informative. Looks like a really good response. So I think the session today was really, really good. Cass will be joining us again on the 5th of October to go through appointments of managers. So if you would like to join us again then, please register on the News on the Block website. The recording of today's session will be available this afternoon, so I can send that out if anyone wants to watch it back, also for anyone that didn't manage to join us live today. Yeah, other than that, thank you very much for your time today, Cass.
You're welcome.
Been brilliant. Everybody else, obviously keep a look out on the News on the Block website for any of our other webinars and Cassie's session on the 5th. Otherwise, thank you for joining us today.
Thanks, everybody. Take care.
Thanks, Cass. Bye.
Bye.